Hello, everyone. Harry here to talk about one more step toward this possible crazy, quixotic, and fantastic potential resolution of disqualifying Trump from the ballot based on the 14th Amendment. And this, the appeal of both parties to the Colorado Supreme Court. All right. I think some people were a little skeptical at my take on the trial court opinion. Nobody listening here. But it sounded like a Trump victory, and he trumpeted it. And my take was, I think this is 95% against him, and the 5% a court of appeal could do. And that was the important thing. So now you have what you really needed and no court could do, which was an adjudication on the facts that Trump had engaged in an insurrection. So we have this 102-page ruling by Judge Sarah Wallace going through his intent, everything that happened, making credibility findings. And we have this sliver at the end saying, however, he's not an officer within the meaning of the provision of Section 3 of the 14th Amendment, which basically says, hey, if you were an officer and swore an oath of allegiance to the United States and then proceeded to engage in insurrection, you can't be an officer going forward. And Wallace, again, said, this is the judge in Colorado, he did all these things to disqualify him. And again, we're talking about a qualification under the Constitution. If you don't meet it, same as if you're 34 years old, you may not be president. He did all these things, but my interpretation, and she hedged, she really telegraphed, higher court, you can do this. I'm a little scared to do it myself. I need really clear and convincing evidence. It is a presidential election we're talking about. So she held that the list, since the list in the 14th Amendment doesn't say officer only, that it wouldn't cover doesn't say president. It does talk about senators, representatives, and any officer of the United States. And she said a president is not an officer of the United States. Now, proponents of this theory, including J. Michael Ludig, Larry Tribe, have really ridiculed this holding, saying, it's absurd. And it would mean, the Colorado Secretary of State said it amounts to a get out of jail free card for the president, which makes it sound like, a terribly un-American principle. And Tribe and Ludig point out, so this would mean that back when this was passed to keep the former rebels from having the reins of power, it would mean that not just a representative, but Jefferson Davis himself, president of the Confederacy, wouldn't have been barred from running from and becoming president. All that's true. It's also, I don't think it's that silly a claim, and it's one that the U.S. Supreme Court in particular might be attracted to. It's not on the list. You can imagine reasons why not. So, but the main thing is, it is what it is. In order to get to the Supreme Court, you would need all these rulings to be made. I don't think the Supreme Court is going to take up the issue if a state court hasn't ruled that he's disqualified. Why would they borrow that trouble? Could imagine circumstances in which they would, but much, much less likely. So you need a state Supreme Court making that determination. So now the table is completely set for the Colorado Supreme Court to not just agree with, but defer to all these factual findings. That's, again, the real importance of having a trial court do this. In the absence of it, imagine it goes to the Colorado Supreme Court or the U.S. Supreme Court and, ask this factual question. Did Donald Trump do this and do that? Was there evil and insurrection in his heart? And a court of appeals would say, we don't do that. We do legal questions, not factual questions. But now that's been done. So it goes to the Colorado Supreme Court. And I try to shy away from analyses and predictions that rest on the party affiliation of the justices on a court, but I think it's maybe worthy of mentioning that court, the Colorado Supreme Court, is overwhelmingly, maybe unanimously, Democrat appointed. So if one puts truck by those things, one might think, wow, you couldn't have a better situation. So from a week ago, when it was quixotic and come on, could this really, really happen? It seems to me there's a real fighting chance now that the Colorado Supreme Court adopts what Wallace has done and adds that little smidgen of officer, and now we're off to the races on the U.S. Supreme Court, and all bets are off. And I mean that in both ways: off to the races, because this all has to be expedited because Colorado's got to finalize its ballot, and all bets are off because the U.S. Supreme Court. There remain other ways, Colorado too, that they could reverse Wallace on some of the things she's done. In particular, they might say her definition of insurrection is too broad as a matter of federal constitutional law. But that risk has always been there, and I stand by my point that what she has done is, 95% of the way. I think I use maybe this a little contrived as a metaphor, but she built the huge sundae with it, all the nuts and everything, and declined to put the cherry on top, but it is just ready for the Colorado Supreme Court. Okay. Both parties now have appealed in this very summary fashion, which is what you do when you're expediting it. And to reaffirm what I've been arguing, you have one little sentence from the challengers saying, did Wallace wrongly interpret that phrase in the 14th Amendment to exclude people running for president, whereas Trump has a whole series of things that he's fighting at and trying to get reversed, of course, any one of which could win the day for him. But they include, importantly, and this is the claim that I think will be really one of two that are front and center in the Supreme Court if it goes up to the Supreme Court. May a court and may a state court actually make the determination of whether a particular candidate for office has engaged in insurrection, or is it something that requires a decision by Congress? That to me has always been the kind of worry about where the U.S. Supreme Court would come out. And to, the credit of people like Ludig and Tribe and the scholars who've argued for it, they've all recognized only the Supreme Court, if Colorado takes them off the ballot, Supreme Court's going to absolutely jump in and fast. You can't have them on the ballot some places and not others. Two, as they've said, with this Supreme Court, all bets are off. I'll just say that on this issue, I'll serve it up in much more detail if the Colorado Supreme Court actually pulls the trigger on affirming her on everything but the officer and reversing there. In other words, on holding, he's not qualified on the ballot. But the Supreme Court in other cases, most notoriously, infamously, I'll say, the gerrymandering cases said, we just can't deal with this. This isn't in our expertise. That's a worry that they might do here, except they're reviewing a state court. And it's one thing to have a prudential rule that says we're going to shy away. It's another to say that a state court violated the federal Constitution by not having a similar practice and by doing what? Deciding who's eligible for the state ballot. I think that's a harder path for the Supreme Court to harder position for them to stake out. But, all that will set up and in great detail if we move to the next step, and at which point everybody would be watching this with breathless anticipation. But, I thought then, and I think even more, as much now, that the opinion from below made that took a giant step toward that prospect. And a fast one, or these other ones will be fast. They've called for expedited review in the Colorado Supreme Court. They'll likely get it. All of this probably has to be decided by January in order for the Colorado ballot to be finalized. So if this plays out, it's going to play out quick, and it'll be kind of a breathless moment, not just in constitutional law, but in politics, and the whole prospect of a kind of, from out of the solar system solution to the whole Trump nightmare. Not ready to say it'll happen by any means, but we are closer, and it is a fascinating prospect. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.